She managed to have no problems paying her lawyer upward near $20,000 to never ending litigation on custody, but yet she can't seem to pay her child support.
This court had to tell Mr. Feldbauer to follow court orders and allow my client to have parenting time with her son.
This is the matter of Feldbauer versus Feldbauer. We are here on the plaintiff's motion to show cause. And Mr. Krupp, anything you want to say?
At the end of the day, my client, she's significantly behind in child support. She managed to have no problems paying her lawyer upward near $20,000 to never ending litigation on custody, but yet she can't seem to pay her child support. She has the money, she has an ability to pay, she knows she does, and if she just doesn't pay her lawyer, then she could probably pay my client, because my client needs money to fund the multi-$1,000 litigation that he's involved in. He needs the money at the end of the day, and it seems like she has no problems giving Thacker Slade thousands of dollars, but can't pay her child support. I think it's completely reasonable to give her 7 days to make her child support current, or I guess go to jail. I mean, because clearly she has an ability to pay. I don't see any bank statement. She has a job. She makes $60,000 a year, but she can't seem to pay child support.
All right, thank you, Ms. Sierra.
Wow. I don't even know how to respond to a lot of that. The reality is our response that we filed clearly shows that my client's not in violation of the court order. We've provided the court, the spreadsheet of the insurance. We have gone through and shown the court the payments. She has continued to make payments that are more than what it should be right now. I am unfamiliar with any law that provides for my client to go to jail because she's paying an attorney for help because Mr. Feldbauer has gone through and obstructed justice here. He has denied parenting time. He has played games. It is the only reason that this case is costing so much money is because Mr. Feldbauer has created a massive situation here that's not in the best interest of this child. To suggest that my client should go to jail because she is asking the court for help so this child can have time with his mom is ludicrous to me. And from what I'm understanding, what I just heard, Mr. Feldbauer doesn't need the money to take care of this child. He wants the money to pay for Mr. Krupp so he can, I guess, file another frivolous motion to show cause. I'm not sure, but I would request that this motion and order, I would request the motion be denied. I would request that the order to show cause be dismissed. My client has not violated one single order as it relates to child support, and I would request attorney fees for having to respond to this motion and be here today.
Mr. Krupp.
Yeah, according to Ms. Sierra, I guess she's current on sport. If she's current on sport, then we shouldn't be here. I totally agree. If she's behind—
Mr. Krupp, let me ask you this. It looks to me like the response indicates that she is under a uniform child support order and she is paying on arrears.
That doesn't solve the problem, Your Honor. At the end of the day, she's behind. She has an ability to pay. The thought that you get behind and then, oh, I'm okay, I pay $5 a month until I'm dead, doesn't solve the problem. My client—
Right. I don't think that I can hold her in contempt under the law, because she is abiding by a court order. If your request is simply that she pay off the real arrearage in full, we can discuss that, but she is not in contempt.
That's Your Honor, she needs to pay the arrears in full. Then she has an ability to pay. She has thousands of dollars, I'm sure, because like I said, and I thought it was ironic that Ms. Sierra is saying that my client is, I mean, every motion that's filed has actually been by Ms. Sierra.
I'm not going to get into that because it's not relevant. Really.
Yeah. At the end of the day,
the question is, does she have the ability to pay the child support in full, the arrears in full today?
Your Honor, she does not have, first of all, she does not have the ability to pay the arrearages in full. Secondly, we don't know what the arrearages are, because as my response indicates, she's been paying support on an order that's incorrect. That's at least $137 more than what the last order should be, what the last what the last recommendation from the friend of the court was. Further, these parties have been exercising equal parenting time since April 26th, when this court had to tell Mr. Feldbauer to follow court orders and allow my client to have parenting time with her son. So I don't have a problem with discussing what the arrearages should be with Mr. Krupp. And I candidly would say that if we're going to do that, I think we need to have another hearing on that, because if we're going to talk about child support, my client shouldn't be paying $606 on a UCSO based on her having overnights that are inconsistent with the judgment of divorce. So I'm happy to talk about it, but I do not think that it's appropriate to order that she's going to pay arrearages because we don't know what they are.
What we do, you check with front of the court and they'll do a printout for you. They'll show you what the.
Okay, all right. I'm going to refer this for an audit and I'm going to deny the motion today.
Your Honor, attorney fees.
So, Your Honor.
I will reserve on the request for attorney fees.
Thank you.
Your Honor, the other issue comes up with I realize that you did a no oral argument on, we have a front of the court recommendation that wasn't objected to. My client didn't object to it. Quite frankly, it resolves the entire case. And Ms. Sierra then filed an objection 3 days late, undisputed.
This was already
decided this case. I've already decided this, Mr. Krupp.
Okay, so we're going to do week on week. The child's starting school. That's the problem. And
there is no problem. You're on an order to show
I'm
cause.
sorry. Okay, I won't interrupt you, if Ms. Sierra. If you won't interrupt me, it sounds like you're jumping down my throat.
Both of you
The
were.
child is starting school, Your Honor, and there was an improper objection. I didn't, it was 3 days late. It is what it is. It needs to enter so the child can, right now the child has to commute to school because she objected. The order should enter at the end of the day. No, there was no objection to it.
You can file a motion for reconsideration, but I'm not addressing it today. We're adjourned.